The National Industrial Court has held that it is legal not to pay salaries to striking workers during the period which the strike lasted. Justice Benedict Kanyip held that in line with Section 43, subsection 1A of the Trade Unions Act, members of ASUU who participated in the 8-month-long strike are not entitled to salaries. We have details in this report.
By virtue of the International Labour Organization Convention No. 87, workers who embark on an industrial action are not entitled to payment of salaries during the period of the action. Although employers and workers can enter an agreement for which the workers will be paid during the period of strike, when such agreement was not made, workers are not expected to get paid. These were the findings of the President of the National Industrial Court while delivering judgment in the suit against the prolonged strike embarked by ASUU, which lasted for over 8 months. In 2022, ASUU and the federal government were at loggerheads over failure of the government to release of the revitalization funds for universities, release of earned allowances for university lecturers, deployment of the University Transparency Accountability System for the payment of salaries and allowances of university lecturers' renegotiation. When negotiations were ongoing, the federal government approached the court and secured an order of the court directing the striking lecturers to return to the classroom. Today, the court has delivered judgment on the substantive case. Delivering judgment, President of the Industrial Court noted that in line with Section 18 of the Trade Dispute Act, no employer shall embark on lockouts and no worker shall embark on an industrial action when trade dispute is apprehended and reconciliation ongoing. The court also held that the federal government cannot force ASUU to accept payment through the IPPIS so long they confirm to the budgetary allocation. The federal government is wrong to have imposed IPPIS on ASUU, but expressly stated that members of ASUU who embarked on the 8-month-long strike are not entitled to payment of salaries during the period the strike lasted.
Can you imagine students that are Nigerians that are not Nigerians, and there are students in Nigeria's public schools that were shut out for this long duration of time? Can you imagine the infrastructure that had been destroyed for the period of prolonged strike?
I have never seen where it was brought to the lower court attention that there is a matter touching on the same subject matter pending at the Court of Appeal, and the court will insist on proceeding with such matters. There is hierarchy of courts in Nigeria. There is an application that is pending at the Court of Appeal, stemming further proceedings in this court.
The court has also struck as Section 43(2) of the Trade Dispute Act, which gives the minister the sole authority to determine if a lockout has been staged by an employer against his workers. This, the court say, is in contravention of Section 6 of the Constitution. The court also held that only the court has the sole powers to determine when a lockout has been staged by an employer. Celestina Iria, TVC News, Abuja.